Tenant rights and defenses in California. What landlords don't tell you. If you're facing eviction in California, here's the truth. Just because your landlord filed doesn't mean they automatically win. You may have powerful legal defenses, but if you don't use them correctly and on time, you lose fast. In California, thousands of tenants lose their homes every year, not because they did something wrong, but because they didn't know how to push back. I'm going to break down the most important tenant rights and defenses in California in plain English. This isn't about every eviction. It's about knowing when your landlord hasn't followed the rules and how to use that to protect yourself inside the courtroom, not after. Defense number 1, improper notice. Your landlord must follow strict rules when serving you with an eviction notice. If the notice is wrong amount, wrong wording, wrong date, or served incorrectly, you can challenge the whole case. For example, if it's a 3-day notice to pay or quit, but the rent amount is wrong, or the notice is slipped under the door instead of being handed to you, that can be a defense. Landlords also have to use the right type of notice. For month-to-month tenancies, they usually need a 30 or 60-day notice, not a 3-day. No proper notice often means a weak case, and most tenants never even check the paperwork. Defense number 2, unlivable conditions. If the property is unsafe or unlivable, you may have a strong defense. This includes things like no heat, plumbing issues, mold, leaks, or serious structural damage. In California, landlords must provide habitable housing under the implied warranty of habitability. If they don't, you may not owe full rent, or you may have a defense like repair and deduct, or even withholding rent in some situations. But you usually have to give them a chance to fix it first, in writing, with dates and photos. If they still ignore it, you can bring code enforcement or health inspectors in. Their report can be powerful evidence in court. Defense number 3, rent issues or payment disputes. If you already paid or the amount on the notice is wrong, that matters. Landlords sometimes file cases claiming you owe more than you actually do, or pretending you never paid at all. If that's happening, you bring proof. Bank statements, receipts, money order stubs, or even text messages where the landlord acknowledged the payment. You can also check if the landlord is charging fees or rent increases that violate local rent control rules, which is common in cities like Los Angeles or San Francisco. No proof means you're exposed. Solid documentation can force the judge to question the landlord's entire case. Defense number 4, retaliation. A landlord cannot evict you for reporting code violations, asking for repairs, or filing a complaint with the city or health department. If they file an eviction or suddenly jack up your rent shortly after you complain, that can be retaliation, and it's illegal in California. Under California law, there's a time window, often within 180 days, where the court can assume it's retaliation if the eviction follows your complaint. So document everything: date you complained, who you talked to, and when the eviction or rent hike came. That time frame can be your defense. Defense number 5, discrimination. Evictions based on race, disability, family status, or other protected classes are illegal. If you're in a protected class and the landlord suddenly starts pushing you out after you request a disability accommodation or after you have a baby, that's a red flag. In California, this falls under both federal housing law and California Fair Employment and Housing Act. If that happens, it's not just a defense. It's a serious violation that can lead to fines, damages, and even separate lawsuits. Landlord mistakes in court. Even if the case gets filed, landlords still mess up. Common mistakes include missing paperwork, incorrect filings, wrong amounts, Deadlines missed. If you respond and show up, you force them to prove everything. Bring your own timeline. When you got the notice, when you paid, when you requested repairs. If their paperwork says something different, you point it out in front of the court. That kind of detail can throw their whole case off. Reality check. Here's the hard truth. Rights only matter if you use them. If you ignore court paper, don't respond, or don't show up, you lose by default. A judge can enter a default judgment in minutes. You lose your home, your deposit, and your possibility of back rent and court fees, all without stepping into the courtroom. No defense ever gets heard if you're not there and you haven't filed an answer. If you're in this situation, read every notice carefully and note the deadlines. Respond within the time limit, usually 5 days for unlawful detainer in most California courts. Gather proof immediately. Photos, receipts, emails, texts, and any inspection or repair records. Look into legal aid in your area. Many counties have free or low-cost eviction defense clinics. A quick search for your county eviction defense legal aid can connect you with a lawyer who might help draft your answer or even appear with you in court. Timing matters as much as your defense. One missed deadline can change everything. Subscribe if you want clear, no BS breakdowns like this. Plain English explanations of tenant rights, eviction defenses, and how to protect yourself in California housing system. Turn on those notifications so you don't miss the next one. And if you found this helpful, please like it and share it with a friend. I really appreciate it. Thanks for watching. Take care of yourself.